next week the Karen retrial officially goes back to trial. And so
maybe.
Right? I mean, you never know.
Honestly,
in this case, you don't know.
You have no idea.
In this case, you don't know.
Yeah, so this past week we ran a poll asking what Karen Reed updates you'd like to see us cover the most, and we're going to reveal those results shortly. So now let's dive into the latest developments. There's so many things happening just this past week, you know, with
Proctor
has happened.
Yeah.
There's been some questions about third-party evidence, all these different things. And so, but when we ran this poll, 50% of you said that you were dying to hear about new digital evidence claims.
Yeah.
And Lord, you got, this has been nothing but all these different things that have happened with their digital evidence, Google searches, the Sallyport videos being missing, Ring camera footage, all of that. And trust us, we hear you.
Yeah.
But we cannot unpack all of that on this episode, we realized. So instead, we're going to focus on Officer Michael Proctor's firing today.
Yeah.
Well, before Chase gets into it, I just have to say one thing. And I've said it when we first started covering Karen Reed. I cannot not think about the Police Academy movies when I hear Proctor. Every time. Proctor! It's just constant. But anyway, go ahead. And he deserves kind of that criticism.
Well, his name has now become a verb. When you mess up at your work, it's called going full Proctor. Going full Proctor.
Well, maybe he took over the Police Academy saying screaming Proctor. You know, So he's the new one. Chase, go ahead.
So Trooper Proctor was fired. He had three disciplinary hearings that the state police tribunal actually held, and they found that the text messages they sent were inappropriate. On multiple occasions, these text messages, first of all, the night of, or the night or day after, 16 hours after, he's sending messages like, she's a whack job. She's going,
Nutbag was one.
Nutbag. And
that's pretty nasty stuff on there too.
Yeah,
I don't know that I've ever called anybody a nutbag. That's pretty bad.
Yeah,
okay.
Whack job.
Vic says shitbird a lot to me, so there ain't.
He called her a whack job. He called her the C word. And that she's not skating, she's not getting out on this. So he had already made up his mind, like 16 hours after this, that he only had one suspect. And on that text thread, we have high school
investigator
friends.
will tell you, that's not how you're supposed to do it.
No,
if Sean was here,
you follow the
evidence.
evidence.
You follow the evidence.
Yeah, and to make a determination that early is bad policing. And on this text thread, he had friends in high school, he had superiors, he had other police officers, he had people that had no business whatsoever in knowing anything about what's going on in the investigation, that he's giving all this information, he's disclosing medical conditions that she has.
Making fun of medical conditions.
Making fun of medical conditions, talking about looking for nudes, just being completely unprofessional. And in addition, it was revealed that he was drinking on the job, driving his state trooper, his
impressive.
Car.
He drank and then he drove his police cruiser.
Right.
So
that's going full Proctor.
Yeah. That's a lot. That's a lot.
Go hard or go home, buddy.
So the way in which the defense is going to use this is going to, they used it very, very well in the first trial. They're going to use it again in the second trial. Basically the foundation of this case is the work of Trooper Proctor, and what it shows, what these text messages shows, what his conduct shows, is that he was completely biased, completely ignored important evidence, did not do good police work as far as investigating people inside the home or anything like that. He made it very clear that he wasn't going to do that, even in those text messages, saying that the homeowner, reassuring those people in the text thread, said the homeowner's going to catch shit. He's like, no, the homeowner's a Boston cop too. And the jury hated that in the first trial, and they're going to hate it again in the second trial. And that is it. The defense is going to eat up Trooper Proctor again, and they're going to have more ammunition showing that this police officer was fired over how poorly he behaved and his conduct in this.
One thing I want to make sure it's clear too, Chase. I think everything you said was dead on, but I want to make sure people know that just because it's a new trial, you still that is the first trial was sworn testimony. That is admissible.
Yeah.
So you can't. It's not like he can come in and apologize and do all this stuff and say and just admit it up front. He's already lied about it and all these things. So that's coming in. That's coming in.
Yeah.
Well, and it wouldn't have been able to. Timing of this, of course, is that if he had not been officially fired,
Right.
They would not have allowed any ongoing internal affairs investigations to be brought into it. So, I mean, Karen Reed had to be, and her team had to be very excited once that news came out, because it opens up that door, right? So, I did want to, we had on our poll, there was a comment from one of our users that I wanted to share, and maybe you guys can kind of give some feedback to this. YouTube user Graxus commented saying, I'm curious as to if the Commonwealth does not call Proctor as a witness. Can the defense call him as a hostile witness off the bat, or would they be restricted in what they could question him with? It seems the Commonwealth has placed all blame of the issue with evidence onto Proctor now that he's been fired.
Yeah. Well, I think it's impossible for them to not call Proctor. He's a chief investigator, so I think it's impossible.
I think the point on that, and you're right, is you still have to prove. You have to have the burden of proof. You have to go through it all. And if he's not there, then the defense moves for a directed verdict.
Because he can't testify to any of the collection of
evidence. Is there any way he
and,
wouldn't be there?
No.
There's no way.
There's almost no way that they can get in some of the evidence due to chain of custody, due to authenticity of some of the exhibits, some of the evidence that they want to admit. He's the witness by which they get that evidence in, and so they're going to have to bring him up. They can. They're not going to be able to limit where the defense goes. Usually, you're limited in going into the areas in which you're on the direct examination covered, right? But you are allowed to go into areas that question the person's credibility and their bias.
And that door is wide open.
And that door is that door is forever. Is forever wide open when it comes to Trooper Proctor. So, whatever case of the Commonwealth brings, they're going to have to deal with the tainted evidence or the tainted investigation.
The only way to really do that is. And this is what is going to happen. If when he testifies, he's going to come in and just fall on the sword and say, "I'm the worst human ever. I'm the most despicable person. I hate myself. You're going to hate me." And then, but what I did is still true.
Yeah,
that's what. Because if you don't, your credibility's gone. I mean, his credibility's already hair thin. So that's the only way, and that's what the state will prep him to do. Is they're going to start off with just saying introduce yourself, and then they're basically going to say
they should
fall on they have to.
They should get all in front of this and talk about it with the jurors. You're going to hear text messages.
And it's going to hurt.
Terrible.
It's awful, and then he's going to, and that's the first thing you do when he's up there. You don't make him a superhero.
You take away the steam for the defense,
because then the defense comes
just
in
repeating. It's like, we've already heard this.
Yeah. So now you're just beating up on him.
Yeah, now you're just beating up on the guy, and he's a fire.
He's already admitted it.
Yeah, he's already admitted it. He's already done it wrong, and you're just beating a dead horse. And a jury doesn't like having their time wasted.
Well, and nobody likes a bully. And then it makes the defense look like a bully. If you can mention it, but if you start beating up people, when you have cases, my dad, like I said, a long time prosecutor, if he had an elderly woman or something, and she might be a bad person, he would say you have to be very delicate because the jury's going to hate you as the lawyer. Even if they feel like you're picking on them, kind of thing. Nobody likes a bully.
Yeah. So what do you think the defense? All right. So you guys kind of talked about what you think the prosecution strategy will be. What with this defense team that you've seen so far, and obviously we got some new players on the defense team.
Sure.
Which is a nice segue into a former juror who's now on the Karen Reed's legal team, one of the former jurors from the first trial. So how does the defense approach it and not make the mistake that you're talking about? Because I would say the majority of the public opinion that we see on YouTube is that we've got a biased judge. Karen Reed should go free. People also really want justice for John, Officer John O'Keefe. Even though, and some people, it doesn't even matter whether Karen's guilty or not. They want justice, period.
Sure.
So all these factors, like the defense, how do they not come across as sort of shooting themselves in the foot?
So
no pun intended.
This is how I would do it. This is, I think they'll probably have similar. It's kind of like calling a football game, right? You're going to have design plays. They'd like to script out the first 10 plays or so. So you'd have that with each witness, but they're going to have two playbooks. One, if they don't get out in front of it, that's hammering playbook, and then one that's still going to hammer him, but it's just not as forceful. And then you just have to read it. You just have to play. I mean, you just have to feel it. That's it.
It's
and
a
these
part
guys
of
will do that.
It's a part of being a trial lawyer that you have to react in the moment. And Reed's exactly right. They're going to prepare two crosses, and one is going to be if they get out in front of it, and one is going to be, and they, when I say get out in front of it, they talk about all of the bad stuff beforehand, so that they don't duplicate the evidence, so they don't bore the jury with repetitive stuff. They're going to have a second script for that. That's what I would anticipate. And the way that they're going to use this is they're going to sow reasonable doubt. That's, you have what they will characterize as a biased investigation that was biased from the outset, as evidenced by the text messages that he sent out saying, she's not skating out of this one, she's a whack job. And he had already decided who was responsible for this. And then showing his basically lack of integrity. I mean, a lack of integrity and a lack of credibility go hand in hand, and by showing that he is willing to violate any sort of like oath that he has as service to the public, as being a unbiased, following the evidence type of investigator, it's going to make trusting anything that he puts forward and the investigation puts forward as dubious. It's going to be questionable. I mean, one of the pieces of evidence that they thought that was very, very good for them, the prosecution, was a hair that they found that belonged to John O'Keefe on the back of on the bumper of her car.
Yeah.
They towed that car for over 60 miles, okay, through a blizzard, right?
Yeah.
And that strains credibility that a hair is going to stay on a bumper, okay?
Well, if it's 50-50, you've already lost on that credibility side. I mean,
right. Just on that piece of evidence.
Right.
Then you have.
I don't know. You ever got an eyelash stuck to your face?
Yeah, I know, but
it's hard to get off.
But that's what I'm saying. Like if it's questionable in a jury's mind,
and
then the only thing they can rely on is somebody who they've proven lies and does all these terrible things.
That has no reason to try.
How does his hair get there?
Yeah.
I mean, it's on there. So how does it get there? So that makes you incredibly suspicious of like someone trying to make this stick. In other words, sticking to the bumper, sticking to Karen Reed. That is one of the clear ways in which to do it.
Knowing that really, as a police officer, you should not be speaking in the way that you did in these text messages, but you did anyway. Yeah. What are you trying What are you trying to convince people of?
Where's the line? If you're lying about this or you don't do this on your job, that's what. I mean, if I'm a juror, that's what I'm looking at.
Right.
You didn't follow the rules not to drink and drive your police cruiser.
Where's the line for you?
And that's what one of the things we're going to talk about today, because it came out while we were preparing for this podcast.
Yeah.
That Victoria George had a problem with. Victoria George is a alternate juror from the first trial that has now filed an appearance to join the defense team for Karen Reed. She was an alternate juror. She sat through the whole entire first trial, but
as you corrected me before the show, she did not sit in the jury deliberations.
She did not participate in the jury
All
deliberations.
right, so she didn't hear any of that conversation.
I'm not sure if she was not present for the deliberations.
I know she
wasn't participating in the deliberations. Right. This woman has a law degree from Northwestern. She's a Princeton graduate. She's a rule follower, and and the reason why we kind of know this is because like any sort of impropriety that could have possibly been placed on her as a juror, she mentioned to Judge Canone she saw a free Karen Reed, sign. She's not supposed to look at anything that is, and consider it as evidence or anything. That's outside of what is presented in court. Well, she mentioned it. She mentioned driving past that billboard, right, to the judge to make sure that she was still okay to serve as a juror, right? She's already served on 2 juries prior to this and served as a foreperson for one of them. She was pregnant at the time of this trial that she was serving on the jury for, and did not ask for to be excused. If I have a pregnant woman on the jury,
I would,
right. I don't know what she's going through, but I imagine that's not the most comfortable thing to be sitting. I would. If she wants out, I'm letting her out. She didn't want out. She wanted to be involved in this process. This is a person that's very active in the and she found, and for her, it was Trooper Proctor's bias and his conduct that made her feel like the state could not ever prove beyond a reasonable doubt that Karen Reed was guilty of anything in this case, and why she eventually decided to actually join the defense team. But there's a lot of other stuff that played into that. She was instrumental in removing one of the jurors. One of the jurors actually was very critical openly of Karen Reed amongst the other jurors prior to the deliberations, and she brought it to her and another juror brought it to the attention of Judge Cannone, and that juror was dismissed.
Yep.
So she had one of the other jurors actually dismissed. She requested a sidebar with the judge, okay, as a juror, because she knows what her rights are. When she was excluded as a actual deliberating juror, the state of Massachusetts has a very unique way of actually picking alternates. They put them put a bunch of tiles with a bunch of numbers in a little thing. They spin it and they pull out 2 tiles, and that's how the alternates are picked.
It's like bingo.
Right, and it turns out that both her and the other juror were very defense leaning, and she mentioned to the judge that while those tiles were pulled out, no one ever showed her her number, right? And she says that she felt like that it was beyond a coincidence that she and this other juror who had brought it to their attention, that the judge's attention, that this other juror was critical of Karen Reed and had that juror removed, that they both of them were excluded as being deliberating jurors. Mm-hmm. And she had a problem with the fact that Judge Cannone picked a former police officer who had told everyone that he'd been hit by a car in the past as the foreperson for the jury. So all these things weighed into what ultimately became her decision. She basically says that at one point she said, if as a lawyer I was going to be too afraid to stand up for what I believe in, then who's going to stand up for what I believe in? When she just basically feels like she did not get a fair investigation and wants to be a part of the team that's going to try and exonerate Karen Reed. I applaud her for that, but how do you feel, Reed, about her joining the defense team?
Well, we talked a little bit about it. I mean, I think it kind of taints it a little bit in the public eye. And there's nothing that she's done or is doing that is incorrect or wrong. But it feels like, and the public eye doesn't matter when you're trying the case. So, you take all the help you can get. But I think it's going to hurt them in the public view, hurt the defense in the public view, just because the defense is on high ground right now still, even though there was some issues that may have occurred, blah, blah.
Right.
But they, with all the problems that the prosecution has had in the public eye, this kind of gives the public another punch back for the
See, I disagree. Yeah. I think that the public's going to see this as a clear sign.
Well, that's kind of like politics, right? If you're on one side, you're going to see it's clear. You're on the other side, you're going to see it's clear. I'm thinking the people in the middle are going to look at it and go, well, that's not really fair. Even though it is, all these attorneys run focus groups after focus groups after focus groups.
But to have somebody that's already sat through deliberate,
But it would be a great advantage for a lot of things. First of all, the main thing, and this is what I encourage everybody to watch if you're watching the trial at all, is what is the theme of the defense? And with this woman watching the entire first trial, she's going to have intimate knowledge of what themes work and what themes don't.
So that was my point, was that I don't care one way or the other if she is. I don't know if there's rules against or whatever, but I would think somebody would object because she sat there, whether she was able to actually be active, but sat there and watched how a jury like we said, we don't know if she was in the deliberations, but was still able to see all the things
Yeah.
sitting from a juror's perspective.
Sure.
So she has,
Well, you know, it's the
to your
same
point, you could
time,
do focus
you
groups,
could-
but I'm saying she has an advantage
You
that
can
she,
try
now
the
the
case
defense
yourself,
has.
right?
I think.
You can try the case yourself if you want. Like, I mean, you can use any defense mechanism. They've had their time to try that
Yeah.
case. All those
Yeah.
people can do whatever they want to do.
Yeah.
They can go to law school, and a juror can go to law school and jump on
Graduate
there.
and then jump on the case. Yeah.
I mean, and I think that's completely fair.
Yeah.
I mean, it's the burden of the state to prove the case.
That's right.
That's,
Yeah.
I mean, that's it.
Yeah, but I think that in the state has the right to talk to the jurors, the other jurors in
Absolutely.
the case, and I know that they have done that, and it's part of the reason in which they're actually retrying her is because of some of the statements they got from some of the jurors. Because if they found out that they only had one holdout. And that they weren't ever going to get a real conviction, and they know that they've got more than just one person that was a holdout.
And they're looking the same thing with this witness. They're going to be polling the jurors for the theme, what works, what doesn't. So you'll see both sides will have a theme throughout the trial.
Yeah.
And you might not pick up on it the first day, but you'll start hearing it over and over.
Yeah.
And so that's going to be, both sides are going to have a theme. And I don't know what their theme is, but you'll hear it quickly.
Yeah, they focused on the last time a little bit on the third party culprit actual defense, where they said there's another person that could have done this, Brian Higgins,
think
who
they're
had a
gonna
romantic
go
relationship
Bigger
with
go home on that
with
the second one.
Karen Reed. They had Colin Albert, who was a young man that apparently didn't had
Violence issues,
injuries,
yeah.
Injuries to his hand shown in pictures just months after this. The other Alberts that were the other Alberts that were there at the house, that they had the dog that the wounds kind of show what looks like a dog bite. And I think for that reason, I think Judge Cannone is going to allow that third-party culprit. But I think that the basic theme is going to be you can't convict on this type of evidence. Like this is not.
It's kind of like
doesn't
writing a
rise to the
brief.
level of beyond a reasonable doubt, because it's reasonable to doubt whether or not Proctor was biased in this particular case, whether or not he put evidence or tainted it.
It's
just
reasonable to doubt that a piece of hair could survive on a car that was
Oh
towed
my
through
gosh.
a blizzard.
Well, it's kind of like writing a brief, Chase. I mean, don't you think it's you put that strong argument of that, and then the secondary argument is because
There's
people
all
want to
kinds of
blame
other people that
somebody,
can do this.
and the jurors want somebody.
Yeah, they want it to go
So-
somewhere. Yeah. It's like, this could have happened some other way.
Right. So there's gonna be a twofold-
If there's a viable, third party,
Yeah.
I think that in this case, I think
Because
that
jurors
they
want
have,
that.
they want an alternative theory.
Yep.
They want an alternative idea, and I think that they have enough evidence, not only with Brian Higgins, but Colin Albert to be able to present that defense. But I think it's going to be a secondary kind of defense. It's like
I agree.
This, yeah, this is going to be it's a weaker argument.
Yep.
as far as to-
So let's talk about that for a second, because what keeps coming in my head, is the movie Lincoln Lawyer. Okay, have everybody at the table seen it?
Oh yeah, it's been a while. but
Okay,
yeah.
so essentially, if you're a viewer and you haven't seen The Lincoln Lawyer, you should go watch it because Matthew McConaughey is great in it. But what happens is that a lawyer takes a case that he finds out that his client is guilty. But not only guilty, he's guilty for a previous crime that I believe that lawyer sent somebody away, like was part of that person gets sent to jail. And he now knows that there's an innocent man sitting on in jail. And so all these things happen, but at the end he ends up essentially having to, the current client he has to defend him just like he would, even though he knows he's guilty, right? He can't.
That's right.
And so his client ends up being not guilty, sentenced not guilty. But after that, you see where he has talked to the other authorities and gotten, somebody else is coming to arrest him for this previous crime. So this is kind of the same thing, but not the same thing. But I guess what I'm getting at is if Karen Reed is found not guilty, but now all these things have been brought up about Higgins and, this other guy that had the, marks on his hand, what happens?
They can be charged. They could be. I mean, if they have enough evidence, just like anybody else, they could be charged.
So does Karen Reed's team just go, here's everything we found?
Well, they don't have it already.
Yeah.
I mean, essentially.
Yeah, and unfortunately, they're not going to get it. They're not going to get it, but it's in
Yeah.
part. I mean, and that's the real tragedy in all this is that there isn't going to be justice for John O'Keefe, most likely. Okay, there should. I would
If
say
the evidence is already messed up on the person that they were attempting to get a conviction on, the secondary people, the evidence is already messed up.
Yeah.
There's no way.
Right.
If Proctor didn't do what he was supposed to, and he was trying to get this person, and it happens to be somebody else, I don't know if it was or not, but let's say it was. There's no evidence.
Right.
There's
no evidence because he didn't go in the house. He didn't question those people the night of. They didn't take any pictures in the house. They didn't go down in the basement. They didn't pull up the basement floor to see if there was any blood, see if they had a fight. I mean, these are all things that would clear up third-party culprit issues, but it's because they didn't do a proper investigation that
now if they
this
found
is
a
gonna happen.
smoking gun, then yes, but outside of that, it's not happening.
Right. Yeah, it's very tragic and unfortunate that this is happening the way it is, but this is a great lesson in reasonable doubt. Understanding what reasonable doubt is and what's required in order to actually take someone's liberty from them and to put them in jail. When you have the state that has all this power, that has all these resources, and they abuse their power in the way in which Proctor has in this particular case, and when they behave in such a way that you question the integrity of the investigation, the authenticity of the evidence, that is the hallmark of reasonable doubt that a jury hangs their hat on when they say, okay, no, we're not taking this person's liberty from them because you guys didn't prove it. Yep. And I think that you're going to see something similar in the second trial that you saw in the first. They may convict her of the manslaughter. That's the charge that they were hung up on in the first trial was the manslaughter charge, and that is they believe that she might have been involved in his
she could have
death, but she accidentally did it. Right. So that is ultimately I think where it's going to fall again, and honestly, what they should have charged her with in the first place. Yeah. This whole second-degree murder with some sort of malice or intent is stretching it.
I agree.
Yeah.